Distinctive features of the Indian Constitution. This video is by Themis Learning and it deals with those distinctive features which are peculiar to the Indian Constitution. To begin with, these are the primarily important distinctive features of the Indian Constitution which are essential to be written in every competitive exam which is asking about the distinctive features of the Indian Constitution. Firstly, ours is a written constitution. It has an elaborate preamble. It envisages a socialist state, a secular state. The constitution also provides for a very different form of federalism. The federalism which is envisaged in the Indian constitution is very much different from the very concept of federalism as stipulated under the US Constitution. Further, we are providing a parliamentary form of government. We have the rule of law, and we are also talking about separation of powers. The first distinctive feature that we will be discussing is the written constitution. The Indian constitution is detailed, elaborate, and lengthy. Originally, it contained 395 articles under 12 parts and 8 schedules. As of now, we have 448 articles and 12 schedules under the Indian Constitution. Now, the experience of the newly formed nation as a colony of the British with undemocratic crown rule, the leaders thought it was prudent to incorporate not just governance but administration as well. Undeniably, administration and governance are interrelated, and a democratic governance mechanism needs to be supported by democratic administrative setups. This is ensured by incorporating the democratic sentiment for administrative setups to the text of the constitution itself. Based on this historical background, there are certain reasons because of which the constitution is extremely lengthy. The reasons for the prolixity can be enumerated as given on this slide. Firstly, the Indian constitution deals with organization of not only central government but also the state governments. If we look at the constitution of the USA, we're talking about different constitutions for the USA as a country at the central level and separate constitutions for the state for the governance of the state. In India, it is the Constitution of India which is providing the governance as well as administrative setup for not just the states but also the union as well. So we're talking about judiciary at both the union level and the state level. We're talking about legislature at both the levels, and we're also talking about the executive at both the levels. Further, the Indian constitution covers center-state relations in detail. So when we're talking about center-state relations, we need to understand that center and state are not, neither of them are subordinate to the other. Both of them have been given certain powers, and how are those powers supposed to be exercised, or what would be the distribution of those powers, has also been clearly enumerated under the Indian Constitution. Many unwritten conventions of the British Constitution have also been reduced to writing. Like we have the concept of parliamentary privileges, we have the concept of collective responsibility, which exist as an unwritten convention in the British Constitution, but they have been given the word of the text under the Constitution of India. Now, the Indian Constitution also has detailed provisions on fundamental rights. It has detailed provisions for safeguards of minorities and scheduled castes, scheduled tribes, etc., which are primarily due to the existence of various communities and groups. Unlike European nations, which are talking about one identity of the people there, we are a nation with diversity. We are a nation with multiple identities, multiple communities being governed by one single constitution. And hence, it becomes imperative for the constitution to host those provisions which are dealing specifically with certain specific groups. The fifth reason for the prolixity would be the existence of directive principles of state policy. Now, they are non justiciable, first thing. However, the inclusion of them also gives direction to the future governments and gives them a guidance by which the state would strive to be a state of social welfare. Apart from the fundamental details of governance mechanism, many administrative details are also included in the constitution, like citizenship, the existence of government services, electoral machinery, etc. Now the question comes, is the constitution able to address every problem of governance? With this prolixity, the constitution is still not able to address every problem of governance. The constitution leaves a lot of matters to be dealt with by the ordinary legislation. It also provides scope for the growth of constitutional conventions, like what is the relationship between the president and governor with the council of ministers? What would be the relationship of the prime minister and the chief minister with the council of ministers? What is the concept of ministerial responsibility for the acts of the official? How would a state government be appointed? How would the Lok Sabha or the state legislative assembly be dissolved by the president or the governor, as the case may be? And what would be the relations between the president and the governor? These are certain areas which are not really enumerated or not really clearly given under the constitution. However, over the course of time, we have seen the growth of constitutional conventions dealing with these matters. Now, the next significant feature of the Indian Constitution is the preamble. The Indian Constitution has an elaborate preamble. It serves various purposes. It clarifies the source of the Constitution. It talks about the nature of the polity sought to be established. It talks about the goals and objectives sought to be achieved. Further, the preamble does not grant any power but gives the direction and purpose to the Constitution. So it's not talking about any right, it's not talking about any power, it's not talking about any relationship between different organizations within the Constitution. However, what it is primarily talking about is the direction in which our Constitution is going, or the various ethos which would be guiding the Constitution. Now, the first thing that the preamble talks about is the source of the Constitution. The claim that the people of India have given to themselves this Constitution is in line with several other constitutions like USA and Ireland. If we look at the text of the preamble, it clearly states, "We, the people of India, in our Constituent Assembly, do hereby adopt, enact, and give to ourselves this Constitution." Now, these words indicate that the sovereignty lies with the people. The ultimate source for the validity of and the sanction behind the Constitution is the will of the people. The Constitution has not been imposed on them by any external authority, but is the handiwork of the Indians themselves. The source of the Constitution, as the people themselves, affirms the republican and democratic character of the Indian polity. Now, when we are talking about the nature of the polity sought to be established, the preamble declares India to be sovereign, socialist, secular, democratic, republic. Coming to the meaning of these terms, when we talk about sovereign, it implies that India is not subject to any external authority and state has power to legislate on any matter within the constitutional limits. Being a socialist state implies social and economic equality, which is extending to mean absence of discrimination. Talking about secular state, the state does not have a religion of its own. If we say that the Constitution of India, through its preamble, is giving the direction to India to be a democratic country, it means that we are talking about a responsible and parliamentary form of government, which is responsible and accountable to the elected representatives, which is the legislature. India is also envisaged to be a republic, which means the head of the state is not a hereditary monarch, but it would be an elected functionary. Further, it also talks about the objectives and socio-economic goals of the constitution. Looking at the text of the preamble intends to secure to all its citizens justice, which is social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individuals and the unity and integrity of the nation. These concepts of justice, liberty, equality, fraternity, they are basically talking about all the objectives that the Constitution is seeking to implement. They are the various socio-economic goals which are sought to be achieved by the Constitution. When we are saying they're socio-economic, it is because they're talking not just about the economic aspects, but also the social aspects as well. Because when we're talking about justice, we're talking about social justice, economic justice, and political justice. Similarly, we're talking about liberty and equality, which are intending to achieve the goals of a socio economic objective. If we talk about these, emphasizing on the significance of fraternity, liberty, and equality, Dr. Ambedkar, in his closing speech in the Constituent Assembly, said, "The principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. These aspirations are given a concrete shape of fundamental rights guaranteeing equality before law under Article 14 to Article 18, right to freedom under Article 19, etc., and are further clarified by directive principles of state policy, which lay down certain goals for the government to achieve so as to maximize social welfare of the people." Now the question comes, is preamble a part of the constitution? Yes. There were debates as to whether preamble is a part of the constitution or not, and these debates were essentially important because based on the fact whether the preamble is a part of the constitution or not, it could be amended. In Re Berubari case, the Supreme Court had held that the preamble is not a part of the constitution, but later, in the landmark judgment of Keshavananda Bharati versus State of Kerala in 1973, the Supreme Court gave an elaborate verdict which inter alia said that the preamble is a part of the constitution and is subject to the amending power of the parliament as any other provisions of the constitution, provided the basic structure of the constitution is not destroyed. Here, the Supreme Court clearly said that the preamble can also be amended, provided that we are not doing away with the basic features of the constitution or the basic structure of the constitution. Given the fact that the preamble can be amended, also makes it a part of the constitution. The next distinctive feature is for the socialist state. The word socialist was not there initially in the preamble. However, it was introduced by the 42nd Amendment Act in 1976. The concept of a socialist state, which was erstwhile implied in the various provisions of the Constitution, now became explicit, and India's commitment to this ideal has been identified and strengthened. The term socialist is not defined in the Constitution. However, it does not envisage doctrinaire socialism in the sense of insistence on state ownership. It does not mean total exclusion of state enterprise. India focuses on mixed economy, where both private and public sectors exist simultaneously. The Supreme Court has on multiple occasions referred to the concept of socialism and used this concept along with directive principles of state policy to assess and evaluate economic legislation. The Supreme Court has highlighted that the principal aim of socialism is to eliminate inequality of income, status, and standards of life, and to provide a decent standard of living. In Samatha versus Andhra Pradesh, the Supreme Court stated while defining socialism, establishment of the egalitarian social order through rule of law is the basic structure of the constitution. Further, India is talking about a secular state. The concept of secularism here is very much different from the French concept or the concept of secularism under the US Constitution. The term secular was also not present in the original constitution, but it was introduced by the 42nd Amendment. Even before 1976, the concept of secularism was very much embedded in the Indian constitutional jurisprudence. The term secularism is difficult to define and hence has not been defined under the constitution, though an attempt was made to do so by the 44th Amendment, which stated secular to mean a republic with equal respect for all religions. Now, despite the difficulty in defining, the concept of secularism can be said to be based on certain postulates. The first one is that we do not have any official religion in India. Secondly, no state recognized church or religion exists here. We are guaranteeing freedom of religion. And fourthly, we have outlawed discrimination based on religion. By implication, these provisions prohibit establishment of a theocratic state. In S.R. Bomai versus Union of India, the Supreme Court stated that secularism is a basic feature of the Constitution. Indian Constitution is neither anti-religion nor does it create a wall of separation between state and religion. It is also not based on the neutrality of religions. It is based on the philosophy of equal respect for all the religions. The state must keep away from religions except for the purpose of its regulation when it comes in the way of other rights of the individual and constitutional values. Coming to federalism, federalism as the Indian experience is quite different from other federal countries. The question generally comes here is that the structure of the Indian polity, is it federal, unitary or quasi-federal? To answer this question, it becomes imperative to understand the characteristics of a federal polity. The first characteristic is distribution of powers. Now, this distribution of powers is supposed to take place between the central government and the government of the constituent states. Secondly, we're talking about supremacy of the constitution. The constitution should be binding on the federal and the state governments. Neither of them can override the provisions of the constitution relating to the power and status which each is to enjoy. Now, whatever power and status we're giving to the states and the union government, they have to be clearly defined under the constitution itself, and that constitution will be supreme. Thirdly, there should be a written constitution. A written constitution is important as in the absence of a written constitution, it becomes politically impossible to maintain the supremacy of the constitution and to maintain the relationship between the constituent states and the central government. Fourthly, we need to have a rigidity attached to the constitution. The supremacy of the constitution does not imply constitution is legally immutable. Rather, it implies that the power to amend the constitution shall not be confined exclusively to either the states or the central government. Further, what is important for a federal system is to have authority of the courts. The authority of courts is needed for two reasons. First, to prevent the federal and state governments from encroaching upon each other's powers, and second, to constitute a Supreme Court not dependent on federal or state governments and having the final authority over the Constitution's interpretation. The divergence from traditional concept of federalism can be seen in the Indian Constitution. The Indian Constitution is federal in the sense that it conforms to the aforementioned characteristics of a federal state. However, in certain circumstances, the federal government encroached upon the territory reserved for the states. Some of such instances can be enumerated here. On passing a resolution by the Rajya Sabha with a special majority, deeming it necessary and expedient in national interest to legislate on any matter enumerated in the state list, the parliament will be competent to legislate on that subject for a specified time period, provided the period specified does not exceed 1 year at a time. Secondly, we're talking about emergency provisions, which provide the president and the parliament with the certain powers of making laws during the period wherein proclamation of emergency, financial emergency, or president's rule has been declared. Thirdly, we're talking about union government, which is empowered to issue administrative directions to the states in relation to certain matters. These directions are binding and the constitution provides adequate means to ensure compliance. However, these directions are within the framework of laws made by the parliament and do not go any further. Fourth, the parliament can by unilateral action increase or decrease the area of the state. It can alter the boundary of any state. It can alter the name of any state. And hence, like other federal constitutions, territorial integrity of constituent units is absent. This has been justified on historical factors where more than 500 princely states had to be integrated with the erstwhile territories under the rule of the British Crown. Aware of these peculiarities, the constitution makers left scope for redistribution of territories. The governor of a state may reserve a law passed by the state legislature. This is the fifth point. Whenever such a law has been reserved by the governor, approval of the president becomes important. In the sixth instance, we can talk about the appointment of the governor of a state, which is done by the president. The office of the governor is also held during the pleasure of the president. Now, if we talk about the Indian Constitution, we can say that the Constitution is federal with a bias towards the center. It is undeniable that the Indian Constitution is heavily biased towards the Union. However, such bias was also necessitated due to the historical reasons and political expediency. While the other federal constitutions have been undergoing the transformation of giving more powers to the federal government as and when the need arises, especially with the development of the constitutional conventions and judicial pronouncements, the Indian Constitution has simply acknowledged the transformation and adapted itself to it. Further, there is no identifiable label of federalism which could serve as an ideal for a federal system. Every constitution has certain institutional variations while preserving the essential federal principles. So, which all features which we say are making the constitution to be quasi-federal are essentially those institutional variations which can be found in different forms in other constitutions claiming to be federal as well. So, just because we have institutional variations, we cannot say that the constitution is unitary or quasi federal. It possesses the characteristics of a federal constitution too. Now, what are the distinctive features of the Indian federalism? Firstly, we have single citizenship. The USA has dual citizenship, where a person is a citizen of the country as well as of the constituent state. In India, we have dual polity. However, there is only one citizenship. That means we have governance mechanisms at two different levels. However, a person is a citizen only of India. It is not a citizen of a particular state. A person would be a resident of that state or an ordinary resident of that state, but the citizenship would only be for the country which is India. We're also talking about a single constituent authority. The USA has given the right to the constituent states to frame their own constitutions. However, in India, the states cannot frame their own constitutions. Every constituent state has to conform to the Constitution of India. Now, what is happening because of this is the third point, that we are minimizing rigidity and legalism. One problem associated with federalism is rigidity and legalism. Despite being a lengthy and written constitution, the Indian constitution has tried to minimize rigidity and legalism by adopting a long list of concurrent items, giving power to the president to legislate under certain circumstances, and an all encompassing amendment procedure, which is the right balance of flexibility as well as rigidity. The next distinctive feature of the Indian federalism is the concept of emergencies. During the normalcy, the constitution is federal. However, during the times of war and other emergencies, it is designed to work as a unitary constitution. Even other federal constitutions have adopted the same practice, with the judiciary giving the widest interpretation to the federal defense power. The fifth distinctive feature of the Indian federalism would be the unity in basic matters. Attempts have been made to devise unity in diversity. We have all India services. We have uniformity in fundamental laws, which are civil and criminal in nature. We have single citizenship. And also, we have a single and unified system of judiciary. The point 6 is relationship between union and the states. The states and the union are not competitive rivals. Rather, they are placed in a harmonious relationship with each other. However, an overriding power is vested with the union in all those cases wherever it is necessary for national and public interest. Next important feature of the Indian Constitution would be the parliamentary form of government. Indian Constitution provides for a parliamentary form of government. Here in this picture, you can see a very beautiful illustration of the new parliament building in the front and a circular image in the picture itself, which is depicting the old parliament building. Now, what are the essential elements of a parliamentary form of government? Firstly, we have a presence of a nominal head of the state who acts exclusively on the aid and advice of Council of Ministers. Secondly, the cabinet or the Council of Ministers is the real executive. It consists of the members of the leading party in the legislature. Thirdly, the tenure of the cabinet is dependent upon the will of the legislature. Fourthly, the cabinet has a collective responsibility. This implies that the cabinet, at all circumstances, must agree. If there is disagreement among the members, either the cabinet as a whole or the disagreeing members of the cabinet must resign. Fifthly, the prime minister holds a dominant position in the cabinet. Now, what is the difference between parliamentary and presidential forms of government? The first difference is that in a parliamentary form of government, the head is nominal, who acts on the advice of the Council of Ministers. In a presidential system, the president is the real executive and not just a nominal head and exercises his powers with his own discretion. Second, the executive in a parliamentary form of government is accountable to the legislature, whereas it is not the case under a presidential form of government. Thirdly, in the parliamentary form of government, ministers are appointed from the legislators and are chosen by the prime minister. In the presidential system, the president appoints the ministers. The fourth difference is in the fact that in the parliamentary form of government, the president is bound by the aid and advice of the Council of Ministers, which is essentially composed of selected members of the parliament. In a presidential form of government, the president has no such restrictions and can take decisions as per his discretion. So, in a way, what point number 4 is trying to convey is that the executive, which is the president, has an influence of members of the legislature as well. However, in the presidential form, we see a higher level of differentiation between the legislature and the executive. Now, why did India adopt the parliamentary system? See, we had a familiarity with the system because of the Government of India Acts of 1919 and 1935. Secondly, there was provision of effective leadership in times of emergency, which is possible in the parliamentary form of government. Thirdly, we've tried to ensure harmony between the executive and the legislature. We're not talking about a clear cut distinction between the two or clear cut separation of powers between the two. However, what we're talking about in this case is that we're striking the right balance, we're ensuring harmony. Fourthly, we've assigned primary responsibility on the executive, which is assessed regularly through the parliamentary questions, resolutions, etc., and periodically through the will of the electorate. Now, with respect to India, the advantages of the parliamentary system can be discussed as it is amenable to quick decisions, executive is accountable to the legislature, and the fact that the functions of the head of the state are separate from the functions of the head of the government. The next important distinctive feature of the Indian Constitution is the rule of law. A.V. Dicey has been considered the proponent of the doctrine of the rule of law. His writing on the British Constitution in 1885 suggested the following ideas on the rule of law. First, he talks about absence of arbitrary power and supremacy of law. The law is supreme, that is, no man can be punished without a corresponding legal provision and trial before the courts. The government cannot take action against any individual as per its own fiat, but only under a legal provision. Rule of law acts as a check against the arbitrary exercise of power by the government. The second point is equality before law. The law does not discriminate between the subjects and provides equal treatment to all. Every person, irrespective of the rank and condition, is subject to the same set of laws and jurisdiction of the ordinary courts. The third point is predominance of legal spirit. It embodies the principle that the Constitution recognizes the individual liberties of the individual and the judiciary enforces it. Now, the rule of law does not have any fixed connotation. Its broad emphasis is on the absence of any center of unlimited power in the country. Rule of law does not imply rule according to the statutory law, primarily because even the statutory law might be harsh and discriminatory. Rather, it refers to a higher kind of law, which is reasonable, just, and non-discriminatory. It encompasses within itself values such as constitutionalism, absence of arbitrary power, liberty of the people, independent judiciary, etc. Now, Dicey's rule of law is on the basis of absence of arbitrary and discretionary power, equality before law, and legal protection of certain human rights. And these ideas remain relevant and significant even in present times, especially in a democratic country. However, based on certain practical experiences, certain exceptions have emerged to the principles of the rule of law. The first exception is the universal growth of the broad discretionary power of the administration. The second one is growth of administrative tribunals, and the third one is preventive detention. Now, talking about the rule of law and how Supreme Court has dealt with it, in Bachchan Singh versus the state of Punjab, Justice Bhagwati stated that rule of law excludes arbitrariness and unreasonableness. It is necessary to have a democratically elected legislature to make laws, but that power should be unfettered. There should be an independent judiciary to protect the citizen against the excesses of the executive and the legislature. In the judgment of DC Vadhva versus the state of Bihar, the Supreme Court invoked the rule of law concept to decry too frequent use by a state government of its power to issue ordinances as a substitute for legislation by the legislature. Further, emphasizing on the principle of rule of law, the opinion of Justice H.R. Khanna, which was the dissenting opinion, in the case of ATM Jabalpur versus Shivakant Shukla in the year 1976, is extremely important. Despite the fact that it was the dissenting opinion, it is important as this dissenting opinion reflects the true and correct position of the law as per the present law. So, what was stated here is that rule of law is true antithesis of arbitrariness. The rule of law has come to be regarded as the mark of a free society. Its content is different in different countries. It is, however, identified with the liberty of the individual. It seeks to maintain a balance between the opposing notions of individual liberty and public order. In a long chain of authorities, the Supreme Court has laid stress upon the prevalence of the rule of law in the country, according to which the executive cannot take action prejudicial to the interest of an individual without the authority of law. There is no valid reason to depart from the rule laid down in those decisions. Now, the final distinctive feature of the Indian Constitution that would be discussed in this video is separation of powers. In its true sense, the principle of separation of power implies that the three powers of the government, which is legislative, executive, and judicial, are vested exclusively in three different organs of the government with no overlapping, either of persons or functions. The leading example is the United States of America. Article 1 of USA's Constitution vests all legislative powers with the Congress. Article 2 vests all executive power with the President. Article 3 vests the judicial power in the Supreme Court and the inferior courts as established by the Congress. In India, the Constitution does not speak for a strict separation of power. However, functions of different parts or branches of the government have been sufficiently differentiated, and consequently, it can be said that the Constitution does not contemplate assumption by one organ or part of the state of functions that essentially belong to another. Now, while executive power is vested in the President, provisions are simply made for the Parliament and judiciary without vesting the legislative and judicial functions expressly in a body or person. Though the Constitution of India does not accept strict separation of powers, it provides for an independent judiciary with extensive jurisdiction over the acts of the legislature and the executive. In terms of independence, Separation of powers is the basic feature of the constitution. Further, India has a parliamentary executive like England. Cabinet members are essentially MPs. Hence, the cabinet acts as a bridge between the legislature and the executive. And in light of this, it would be extremely imprudent to envisage a system wherein the executive and the legislature are in absolutely different persons. Now, there are certain other distinctive features as well, like independent judiciary, judicial review, fundamental rights, fundamental duties, universal adult suffrage, and independent constitutional agencies like CAG, which is the Comptroller and Auditor General, ECI, which is the Election Commission of India, and UPSC, which is the Union Public Service Commission. So, all of these things together form the distinctive features of the Indian Constitution. I hope this video brought in a lot of clarity with respect to what are the distinctive features of the Constitution. We have talked about these distinctive features in extreme detail, and I hope if a question comes in competitive examinations or in your subject law examination or your constitutional law examination, you would be able to answer that question in extreme detail. Thank you for watching, and I would really appreciate if you would like, share, and subscribe to this channel.